Welcome back to the Emily Show. There is a lot to talk about this week, and if you have not been keeping up with the live streams, well, then you might not know that the Karen Read case is off at a full-out gallop as it gets ready to start trial in April, really on April 1st. I'm not joking, really on April 1st, 2025. There's a lot of discovery litigation going on in the Lively Baldoni case, and we're expecting some new filings right after this episode airs because we are airing on Monday, February 17th, President's Day, which is a court holiday. So Tuesday is going to be a busy day in court. But in interesting news, that Jay-Z Diddy civil litigation, yeah, that got dismissed. We're going to talk about that too. Oh, and Diddy's really mad over a docuseries I haven't watched yet and is suing NBC for like $100 million. We'll touch on that briefly. I told you it was a lot. We should just get into it. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. Okay, before we get all the way into it, yes, I am wearing a new fax hat from the Law Nerd shop, though by the time this episode airs, it is probably already sold out. But we do have new items in the Law Nerd shop just for you. So if you are ready for all of your spicy Law Nerd goodies, make sure to head over to Law Nerd Shop at lawnerdshop.com. And if you never want to miss a drop again, you need to make sure that you are signed up to the Law Nerd app or join the Law Nerd Lounge for exclusive first access to all of our merch drops at lawnerdlounge.com. It is our members community within the app. It is a community within the community if you are interested, but there is lots of goodness over at the Law Nerd shop, and all those links, of course, will be down below. Thank you to all the Law Nerds who've been so excited about this drop, and we will give you a preview of some of what's in the shop towards the end of this episode, because I know you're like, wait, the Jay-Z case got dismissed, there's discovery fights, and something happened in the Karen Read case. Emily, what? I know, we're just getting into it. Starting with Karen Read, because Karen Read will be back in court on Tuesday, February 18th, to go over the discovery motions that were just recently filed. We are now entrenched in that pre-trial litigation. And yes, even though this is a retrial, pre-trial litigation needs to happen again. The Commonwealth has new experts. The defense has expanded the scope of some of their experts. The defense has been given new video that just was never turned over before since 2022. That who knows? They're just getting that now, and they still haven't made their motion to dismiss yet, which we are waiting on. That will be filed on February 21st. Then the Commonwealth will respond. Then that will be in court for hearings too. That's the motion to dismiss, where I expect to see the bulk of the defense arguments over Brady discovery and whether or not the Commonwealth violated Brady by not turning over things like the videos that are still being turned over. The defense has made motions to turn over video, including all the metadata. I'm not confident that that still exists based on the filings we've seen from the Commonwealth. The Commonwealth made motions to exclude some of the defense experts. So in the motions that are going to be argued on Tuesday, we have seen the Commonwealth's motion to exclude the ARCA experts. If you watched the first trial, we referred to them fondly in the chat as the crash daddies. They are biomechanical and biomedical engineers that have quite a lot of experience with accident reconstruction, the effects of force and physics on the human body, depending on the crash. You might remember that they were very thrilled that they actually made like a yeet cannon to fire off whiskey glasses to see if a glass hitting a SUV, specifically a Lexus SUV taillight, would cause the type of shatter pattern that we saw in the Karen Read case.
Myself and one of our lab technicians at ARCA, we designed and developed a pressurized air cannon. So it was capable of firing a projectile such as a drinking glass at the taillight. So it essentially, you can think of it kind of as a giant cannon, but it had a barrel, and then there was a valve that would open rapidly and directly behind.
They yeet cannoned a drinking glass so they could yeet cannon a drinking glass at a car and see if it would shatter a tail light. His job is Mythbusters. And you'll remember that they were not hired by the defense or the Commonwealth. They were hired by
the FBI.
and they were part of the federal investigation that is still ongoing and ever present in this case. So they came in and testified after an extensive voir dire process outside the presence of the jury because discovery had not been turned over. Why? Well, the judge ordered that the defense couldn't interview the federal witnesses or talk to them because there's a lot of information sealed with regard to the federal grand jury, and it was unclear if one side or the other could talk to federal grand jury witnesses and witnesses that had been hired by the feds. So the defense said, fine, we won't talk to them other than to see if they're available. And then the prosecution said, we need discovery. And the defense said, well, we don't have it either. So come on in and let's question them together in a voir dire process. And that's exactly what the court allowed before they testified in the first trial. The Commonwealth is now making a motion to exclude those two experts for the same lack of discovery, saying that the defense has not and is unable to turn over the adequate discovery under Massachusetts Discovery Rule 14. But in the first trial, the court handled this with a voir dire because these witnesses are in the very unique position of evaluating this case being hired in a federal grand jury that is ongoing in the background while a state level prosecution is ongoing. It's an incredibly unusual circumstance that is still ongoing. Do I think Judge Cannoni will change her ruling with regard to the ARCA experts? No. Is it interesting to see the Commonwealth saying we don't have discovery after we've seen defense motion after defense motion saying, hey, we don't have discovery? Yeah, it's a little rich at this point, but based on all the motions, it does not seem that the defense is withholding discovery. It seems that they don't have anything additional than what was turned over originally. If they do, they're required to turn it over. So we're going to hear some argument over those experts. I think Judge Cannoni is going to hold to the same ruling. We also saw a motion from the Commonwealth for reciprocal discovery that had a very interesting paragraph in it that did not make sense to me and wasn't clarified until I went through some of the defense motions. Let's talk about what's unusual here. When I was reading through the Commonwealth motion for reciprocal discovery filed on February 11th, 2025, I stumbled over a paragraph like 3 or 4 times because it did not make sense to me at all. The Commonwealth is requesting, quote, any written or recorded statement as well as any oral statement reduced to writing of any individual whom the Commonwealth intends to call as a witness at trial, including but not limited to such statements contained in defense investigator reports or other non-legal reports. And I was sitting there going, is this a typo? No, it's not. In the defense motions filed on the 11th and the 12th, the defense made a motion asking the court to reconsider a prior order on reciprocal discovery wherein the defense was required to turn over evidence that would be used as impeachment. Often, impeachment evidence, things that you're not going to use unless the other side calls a witness and that witness testifies contrary to a piece of evidence you have, impeachment evidence isn't turned over. Things like video recordings, digital data, that sort of thing. And so the defense is asking the court to change the ruling this time so that the defense does not have to turn over impeachment evidence until before they intend to use it. If the witness is called and if the witness testified and the defense said in the first trial it was their belief and their opinion that the prosecution was able to then question the witnesses about that impeachment evidence, and then when the witnesses testified, they were able to mitigate it or modify the way they explained something because they knew what was coming. Now, witness statements made by an investigator are often turned over, but things like digital data, location data, photographs, videos that are just used for impeachment often aren't. So it'll be interesting to see how this is argued on Tuesday over the matter of evidence that will solely be used for impeachment. And the defense made numerous discovery motions of their own, which I covered in depth on the live stream. But in some, they are asking for all of the forensic data and the metadata that goes with those videos that have been turned over late, and the chain of custody. Who turned them over and when? How? Who decided to save them? Where did they even come from? And we're going to see a lot of conversation about that on the 18th, but I think we'll also see a lot more about that in the motion to dismiss that we know is pending from the defense. And finally, the defense made a motion to exclude a Commonwealth expert, and it seems that this is the Commonwealth expert brought in to rebut the defense expert, Dr. Marie Russell, who's going to be testifying about the nature of the injuries to victim John O'Keefe's arm. Her opinion, in sum, is that those injuries were caused by a dog and not by a vehicle. The defense has argued, using the court's prior ruling, to say only medical experts can testify about the medical cause of injury. Well, the Commonwealth's expert is clearly not a medical doctor. And so the defense is saying, look, in the last trial, you did not allow non-medical experts to give an opinion about the medical cause of an injury. So in this trial, we are asking that you disallow this expert to come in and talk about the nature of the injuries to the victim's arm. I'm interested to see if the court's even going to have a hearing regarding the expertise, because whether or not someone's a doctor doesn't need a hearing. It's very clear. And the Commonwealth's expert made clear that they are not a medical doctor. So I'm interested to see if there's even a hearing on that, or if the judge just rules on the argument that's going to be provided on Tuesday. It's going to be an interesting day in court with all these motions in front of us. And I said discovery was heating up in the Lively, Baldoni et al. Federal suits, because there are a bunch of them. The New York Times is now answering in the federal case where they have been sued. The Lively parties are saying that they are going to have an amended complaint and asked the court for a deadline in March. And the court was like, no, I'll give you till Tuesday. So we will see that filed or not on February 18th if there is an amended complaint. We have also seen Blake Lively individually sued in Texas by Jed Wallace and his company. We saw his name and company mentioned in the CRD complaint that was linked in the New York Times article and made available to the public, even though it's an administrative complaint. But he was not sued when Lively sued Baldoni, Wayfarer, and the PR reps in New York federal court. So he has now sued Blake Lively for defamation in Texas. I'm interested to see if in the amended complaint, he is also sued in New York federal court and they try to remove the case from Texas to New York. But there are going to be some interesting questions with Jed Wallace suing Blake Lively in Texas regarding that CRD complaint that was linked again to that New York Times article for defamation and other causes of actions. Because if that falls into a gray zone of litigation privilege because it was an administrative complaint that did not become a lawsuit yet, then it's going to be a very interesting process through that defamation suit. And I think there will be a lot of argument that Jed Wallace is not a public figure and in fact tries to be not a public figure because of the nature of what his company does. Lively, of course, alleges that his company is the social media manipulation company that was discussed often in the text messages between the Baldoni parties and the PR reps, saying we're seeing shifts on social because of Jed's work, etc. But in the lawsuit against Lively, Wallace, through his attorneys, describes the company as a crisis mitigation firm engaged by clients to help navigate real-life human crises, threats, trauma, and mental health concerns. It helps primarily families and individuals when they find themselves unjustly attacked, extorted, doxxed, swatted, scammed, or need help navigating through the most frightening situations. So that is how he describes the company, Street Relations, Inc. But it will be very interesting to see if the Lively parties add him to that lawsuit in federal court. If the Lively parties try to navigate this as a public figure defamation, even though in the complaints it says little is known about Jed Wallace, it's going to make it hard to argue he's a public figure. And if we're going to fall into some of the gray zones of litigation privilege with whether or not that CRD complaint that is an administrative complaint but not filed as a lawsuit yet is pre-litigation and not during litigation. So the Jed Wallace of it all is going to end up being, though not as sensational in the headlines, legally, I think, a very interesting case to keep an eye on. And I will be breaking that down more in the weeks to come as we start seeing that initial litigation about that suit rolling in. And then the parties in the federal litigations are all off to the races with beginning discovery, and again are already at odds with one another. They agreed for a brief moment that neither side was ready to go to mediation yet and actually asked the court to modify the standard mediation procedure through the court and say, no, time out. We need more information and we need to start discovery before anyone goes to mediation, because where we're all at now, there's no way this is resolving. And I couldn't agree more. But though there was that brief moment of agreeance, we are back to these parties being horrendously at odds. And I don't think the tenor of the litigation is going to change anytime soon. We're going to talk about attorneys being at odds in a minute as we get back into the Buzbee Spiro of it all with Jay-Z, Diddy, and the civil lawsuit. But we have now seen that the Baldoni parties are complaining of overbroad subpoenas filed by the Lively parties, and that the Lively parties leaked those to the media. The Lively parties were just in court saying, Your Honor, we all need to keep this in court. So if they are going to the media, do they not think this is going to come back around? What is happening? In their latest filing to the court, the Baldoni et al. Parties on February 14th take a moment to throw some shade, though this filing is not horrendously hyperbolic. It's actually pretty to the point. We're never going to see a filing in this case without some shade, I don't think, but does point out that the Lively parties are seeking incredibly broad subpoenas for mobile devices, including things like location data and cell site information. So what cellular sites you're hitting. And while you normally see things like call logs or text messages limited down to between the parties, or perhaps a little bit broader, but excluding things like attorney-client conversations and what have you, you don't often see in a civil case location data over such a wide span of time. And they do take a moment to say to the court, quote, "It's hard to overstate how broad, invasive, and atypical these subpoenas truly are. This is civil litigation, not a criminal prosecution, and the Lively parties are not the FBI," which just A, made me kind of laugh, and B, made me wonder if the Lively parties are sending out such incredibly broad subpoenas, would they object to subpoenas that are the same? Would the Lively parties want 2+ years of everything in their phone turned over? I would imagine the answer is no. I don't know the strategy behind seeking such incredibly broad subpoenas when turnabout's going to be fair play. If you would object to these subpoenas, do you need this much information? And attorney Brian Friedman points out the request for real-time location information and data logs reflecting web browsing history. It's quite broad in this type of a case. They go on to say that, quote, "The Lively parties' highly experienced counsel are surely well aware that the subpoenas they issued grossly exceed the scope of permissible discovery as outlined in the Federal Rules of Civil Procedure 26B1, which they then quote, saying that discovery is limited to any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case." They go on to say, unfortunately, it appears these subpoenas are, more than anything else, a media ploy, having been promptly leaked alongside a lengthy and combative statement by the Lively party's legal team, footnote 1, and then they link to a Hollywood Reporter article that I will link down below. And in that article, there is a lengthy statement by the attorneys who were just in court saying, we want to keep this in court, not in the media, and seem to be taking the opportunity to comment on the fact that they're filing subpoenas, which again is not the type of litigation that you see people commenting on. Often you see lawyers commenting on substantive motions or rulings in court, not we're asking for subpoenas because we want all the cell phones. Of course you're asking for subpoenas. You're in discovery. And we haven't even gotten to what the protective orders are going to look like, and there will likely be protective orders over the discovery in this case. So I am going to cover this more thoroughly when we see the parties submitted protective orders in early March, because I'm very interested to see the type of information each side is asking to protect and then juxtapose that to what the sides are asking for in discovery. But yes, these requests on their face seem incredibly broad. I'm very interested to see what the judge does here, and I imagine we will probably see this in court, because if they're starting discovery fights this early, we might see motions for a discovery referee to have a third party navigate this so it doesn't get to the point where it bogs down the court in trying to deal with, Your Honor, you can't let them seriously go after all this information. But also, litigation is not rules for thee and not for me. The point of court, though it doesn't always work perfectly, the point of court is to put the parties on equal footing and then litigate the disputes in front of a judge and a jury from that position. So asking for discovery that you yourself wouldn't turn over in civil litigation is just going to dial up the temperature on everything. And I don't think we're going to see the temperature in this case dialed down anytime soon. And speaking of cases where the temperature is not dialing down anytime soon, we need to talk about what has been going on in some of the Diddy cases. In the criminal case, there was that outstanding issue of the search of Diddy's jail pod and whether or not the AUSAs or the agents at the jail had improperly gotten into attorney-client privileged information in Diddy's legal pads. It said legal on the top, and then it became clear that Diddy's lawyers represented in court that those notepads said legal on top, but then the pictures from the search of the pod showed that the notepads at the time of the search didn't say legal on the top, and the court was pissed about it because don't represent something as being true that's not true to the court when you're a lawyer. There's rules, but there has been ongoing litigation about that and whether or not more information would be sealed away from the AUSAs. There was a taint attorney or a third-party attorney brought in who's not involved in any of the litigation to review those notes and see if any of them are attorney-client privileged and if there was any overstepping. And the judge ruled that there was not, and that is moving along in the criminal case. But the issue of the legal pads that say legal and whether they were attorney-client privileged and whether or not the government had violated any rules and whether or not the entire prosecutorial team need to be thrown off the case, the judge ruled that there was not a violation there. We will get more in depth into that ruling in the future. Litigation has been so busy lately. That's what the quick bits is for. We're just trying to do it quick. And then, of course, there is that Diddy lawsuit against NBC. Diddy sued NBC for $100 million over their Diddy documentary that aired on Peacock called Diddy, Making of a Bad Boy. I have not watched this documentary yet. It is my goal for next week to watch it and look at the legal complaint and see where we stand about whether this is anything or whether this is just another lawsuit. But Diddy is alleging one cause of action for defamation based on things that were said and insinuated in that documentary. If that documentary is based on active, ongoing litigation, on things that are in the public domain, on witness statements, it'll be interesting to see how this goes forward with NBC. Currently, this is in state court in New York, but I was surprised to see Diddy sue over this because I would think the last thing Diddy would want is another civil lawsuit, but here we are. To be fair, Diddy has actually won down on a civil lawsuit because the civil lawsuit that he and Jay-Z were co-defendants in has been dismissed. Not settled, dismissed. Let's talk about that. This was just filed February 14th, 2025. Jane Doe versus Sean Combs, Diddy House Recordings, all of the Diddy businesses, and Jay-Z being added to those defendants. This is a notice of voluntary dismissal pursuant to Rule 41A1A1. Yes, that's the actual section of the Federal Rules of Civil Procedure and reads, quote, pursuant to the Rule of Civil Procedure 41 subsections of the Federal Rules, plaintiff Jane Doe, by and through her undersigned counsel, hereby gives notice that the above caption action is voluntarily dismissed with prejudice. Counsel for plaintiff have discussed this matter with counsel for each defendant who acknowledge and consent to this submission. Emily, what does it mean with prejudice? It means they cannot sue again. Sometimes you will see things dismissed without prejudice, meaning within the statute of limitations. It can be brought again. With prejudice means this action cannot be brought in the future. Jay-Z and his lawyer Spiro made comments on February 14th about it. We're going to go over those in just a moment. But this was the case where the two attorneys were fighting so much that the court's initial order was stop it right now. We are not putting this on an emergency docket. All of you take a breath. We will come to court in short order. And then Alex Spiro had filed a motion for sanctions against attorney Buzbee that was hundreds of pages long with exhibits. This is the ongoing battle between these lawyers that is also playing out in California, where Jay-Z has sued Buzbee for extortion and other causes of action, which I've covered. That is moving into anti-SLAPP litigation in California, which is the motions against strategic participation. And those motions can end a suit at the beginning before they even go to discovery. So we will go through those motions down the road, but they can end a lawsuit and then you have to pay for the other side's attorney's fees. It is a very aggressive statute in California to stop litigation, to silence people. It's really based on suing a publisher or suing somebody who's writing an article to try to wield the power of the courts to silence people. And so Buzbee has filed the anti-SLAPP motion to say that this lawsuit is to chill his participation essentially in litigation, saying, no, I sent a demand letter. That is a normal part of litigation. And you sued me because I sent a demand letter. That's not extortion. That is protected. I am an attorney doing my job. I think this will be very interesting litigation to follow. Again, legally very interesting because demand letters are part of the process. But at what point does a demand letter step over the line? And the court's going to have to evaluate that, including evaluating the likelihood that a party, Jay-Z in this case, can win on the merits of the case. So we will be covering it as that litigation moves forward. But remember, there was more, because then attorney Buzbee, the lawyer for a number of the Diddy accusers, who Alex Spiro, Jay-Z's attorney, keeps calling the 1-800 lawyer, he sued Spiro's firm in Texas. That's now been removed to federal court. There are other plaintiffs involved. That litigation is still moving forward. So this wasn't an agreed upon, we'll dismiss this, you dismiss that. The litigation in New York was dismissed by the plaintiff. The litigation in California is still ongoing, and the litigation with the law firms in Texas is still ongoing. With this dismissal, both Jay-Z and his lawyer put out statements. Jay-Z's statement was on, well, everywhere now, but on Twitter through the Rock Nation Twitter page or X page or Bird app or whatever. It was there and has been picked up by every media outlet that was reporting this late on a Valentine's Friday. So how much traction will it get over the weekend? We will see. The statement says, quote, "Today is a victory. The frivolous, fictitious, and appalling allegations have been dismissed. This civil suit was without merit and never going anywhere. The fictional tale they created was laughable, if not for the seriousness of the claims. I would not wish this experience on anyone. The trauma that my wife, my children, loved ones, and I have endured can never be dismissed. This 1-800 lawyer gets to file a suit hiding behind Jane Doe, and when they quickly realize that the money grab is going to fail, they get to walk away with no repercussions. The system has failed. The court must protect victims, of course, and that's in all caps, while with the same ethical responsibility, the courts must protect the innocent from being accused without a shred of evidence. May the truth prevail for all victims and those falsely accused equally." And I think we will see perhaps litigation falling out from this. Remember, as all of us learned from Elle Woods, claims need like evidentiary support, a reasonable belief that the claim has evidentiary support. Lawyers cannot file, though it happens, meritless lawsuits. And I think Jay-Z is an individual who has not only the money, the resources, the time, and the energy to take this further. I think we will see that here with Jay-Z and his attorneys going after this more forcefully. And whether that is in a separate litigation or whether that is the fight in the litigation in California, he is already suing this attorney. It's going to get interesting from here. And of course, Alex Spiro also made a comment that was picked up by all of the media outlets. And Spiro's statement, reported by multiple outlets, including Law 360 and Variety, said, quote, "The false case against Jay-Z that never should have been brought has been dismissed with prejudice. By standing up in the face of heinous and false allegations, Jay has done what few can. He pushed back. He never settled. He never paid one red penny. He triumphed and cleared his name." I think the statement was important for Spiro because there can be no conversation after that statement about whether this was settled in any way. I think it's very important to clarify because there is often a negative inference ascribed to settlement where it's a common thought, belief, feeling, sentiment that, oh, if they settled, they must have done something. There must be a reason to settle. Not that going through all of this is just onerous and people do not want to be involved in civil litigation. There's often very much a negative inference ascribed to settlement. So I think for Spiro, clarifying that this was dismissed, this cannot be brought again, this was not a settlement and there was no payment, is critical to them, especially as they go forward in other civil litigation. So where does this all go from here? Well, we saw Spiro take what seems to be the new litigation playbook against allegations, which is push back forcefully, push back publicly, and until the judge tells you to stop, make every statement you can defending your client. We saw Spiro hold a press conference about it in this case, breaking down the timeline of statements made by the plaintiff. If the plaintiff hadn't done a media interview, Spiro wouldn't have been able to do that because there are attorney rules. But under the attorney rules, you can respond. And that's what we are going to see play out very much in the Lively Baldoni Wayfarer cases, is that if one attorney makes a statement, it's going to become a game of pickleball where, well, they made a statement, now we make a statement, well, they made a statement, now we made a statement. And then there's going to be much fighting over who said what first and to whom in that case, because again, it's going to matter for the defamation causes of action. So with this, did Spiro's turn up the heat strategy work here? Was this a lawsuit that never should have been brought and Buzbee is bundling together too many civil suits, hoping that they can't all be fought at once? I guess only time will tell, but even though that civil lawsuit is done, the civil lawsuit between Buzbee and Jay-Z is far from done. And I think we're going to learn a lot more about all of this, keeping an eye on that litigation. So this is probably the place where most of the media will stop covering this. And I'm going to be here being like, no, this slap litigation is still going on. We might be here 2 years from now still talking about it. But I want to know what happens at the end of that anti-slap litigation. And I think we're going to learn more behind the scenes about the conversations had in that demand letter, because again, Jay-Z is suing for extortion. So is it part of legal process or is it a shakedown? And we're still litigating that issue in California. Let me know if you're curious to keep following that litigation in the comments down below. And don't forget to get the Law Nerd app. There's live court this week, and there's going to be lots of court dates for the Karen Reed case ahead of Karen Reed starting trial in April this year. We also have Keefe D potentially going to trial in March. Corey Richins is going to be going to trial in May. It looks like Donna Adelson's probably going to trial in June. Is your calendar getting booked up yet? Because mine sure is. Make sure you have the Law Nerd app. And remember, if you have the app, you're the first to know about the latest launches in the Law Nerd shop like this one. So take a look right now. Thank you for being here. Thank you for being a Law Nerd. May the odds be ever in your favor. And I hope you enjoy our spicy launch for Valentine's Day. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So Make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a law nerd.